മായി ബന്ധപ്പെട്ടുള്ള ക്ലാസ്സുകളാണ് നമുക്ക് നടക്കുന്നത്. അതിനുവേണ്ടി പ്രവർത്തിക്കുന്ന എല്ലാവർക്കും എല്ലാവിധമായ ആശംസകളും നേർന്നുകൊണ്ട് ഓൾ ദ ബെസ്റ്റ് പ്രോഗ്രാം. കൺഗ്രാറ്റുലേഷൻ ടു യു. താങ്ക് യു വെരി മച്ച്.
Thank you, sir. I invite Dr. Sona Esteve, IAC convener and coordinator of the Impact Series, HOD of Biotechnology, to address the gathering.
A warm good morning, respected Principal Dr. Shaju Verghese, the resource person of the day, Mr. Shafi, members of the Institution Innovation Council of our college, other faculty members, and dear students both from within and outside our college. It's a proud moment for all of us in getting selected to organize this Impact Lecture Series funded by the Ministry of Education's Innovation Cell. The objective of the Impact Lecture program sponsored by MIC is to support IIC institutes to organize impact lectures and establish a strong connection with the innovation and startup ecosystem enablers at the state and national levels. We at St. Peter's College are conducting the lecture series as per the guidelines prescribed by MIC. Accordingly, we are asked to invite renowned and successful innovators, startup founders, IP experts, and lead experts to deliver motivational and inspirational sessions and share the innovation and startup journey with students and faculties. We are organizing 2 sessions, each comprising 2 lectures of 3 hours duration. Today is the first session, and the second session is on October 9th. It is as per the direction of the MIC that there should be a minimum gap of 10 days between the 2 sessions. That's why the next session is scheduled on October 9th. This lecture series also kickstarts the launch of Innovators Premier League, or IPL, an initiative of the Kerala Startup Mission. The activities under IPL are being driven by the Innovation and Entrepreneurship Development Center of our college. So a wide range of activities are being planned for cultivating innovative talents and to equip young minds with various creative and collaborative skills to navigate through uncertain future. Today, we are indeed fortunate to have Shafiq Sir, Technical Officer, the Kerala State Council for Science, Technology and Environment, as the resource person for the first lecture. I'm sure his talk will enlighten all our students on the role of IPR in entrepreneurship and also motivate many of them to explore the job opportunities in this field. In the second lecture, scheduled at 3 p.m., we have Advocate Matthew John, intellectual property lawyer and registered patent agent, to introduce us to the patent laws. We earnestly seek the cooperation and support from every one of you for the smooth conduct of all the events planned under the IIC and IEDC of St. Peter's College. Let me conclude by once again thanking the Ministry of Education's Innovation Cell for selecting our college and supporting us for conducting the Impact Lecture Series. Thank you.
Thank you, ma'am. It is my great pleasure and privilege to introduce today's guest speaker for the first lecture. We have with us Sri Shafiq S., who will be delivering a talk on the role of intellectual property rights in entrepreneurship. Sri Shafiq is working as a technical officer in the Kerala State Council for Science, Technology and Environment, KSCSTE. He has been coordinating the activities of Patent Information Center, Kerala, since 2007. He holds a post-graduation diploma in intellectual property rights from Indira Gandhi National Open University and has completed a general course on intellectual property conducted by World Intellectual Property Organization, Geneva. He has 14 years of experience in the field of IPR and IP management. He has a rich experience in organizing IPR awareness programs and in conducting prior art patent search to determine the patentability status of the inventions. He is the faculty for the IPR programs of Kerala Startup Mission, MSME Development Institute, and various other institutions. Over to you, sir.
Thank you for the nice introduction. Am I audible?
Yes, sir.
Okay, thank you. So, first of all, I would like to congratulate the organizers for conducting an impact lecture series. And this is the first lecture series, and I'm so happy to be a part of this lecture series. And I would also like to thank Renu Madam for inviting me to this impact lecture series. So I will directly share my presentation. Is the slide visible?
Yes, sir.
Sir.
Okay, so today in this session, we will be discussing about a very relevant topic of the present time, that is intellectual property rights, IPR, and its role in entrepreneurship. So I'm sure that most of you will be unaware of this topic, might be, because it is it's an emerging topic and we are not that much aware of this topic. So in this session, I will be covering a brief overview of what intellectual property rights is and how it plays its role in the development of a startup as well as entrepreneurship. So before I start, I would like to inform you that maybe at the end of this session, we will be having a small quiz on the topic of intellectual property rights, and only the topic will be covered in this session will be included in the quiz program. It will be maybe a 10-minute quiz program will be there. Okay. So with your permission, I'm starting this. Okay. So we are all well aware of the term property, right? Property, the tangible or the physical properties we have, like it can be a movable property like our vehicles, furnitures, and all, and it can even be an immovable property like our land, houses, and all. So we are well aware of the physical properties, and we know how to legally protect such physical properties. And we have similar kind of property which is intangible in nature, which we cannot touch and feel. So such type of property is called intellectual property. And in this session, we will be covering about this intellectual property. So intellectual property is nothing but it is the property created by the human intellect. It is any intellectual activity which comes out from the human brain is known as an intellectual property. It can be an invention, it can be a creative work, it can be a designs, it can be a logos, symbols, or anything. Any intellectual activity which comes out from the human intellect is known as an intellectual property. And if we have an intellectual property, we should have some legal rights to protect, to legally protect such property. So for that, we have got intellectual property rights, IPR. So IPR is nothing but it protects the interest of the owners of intellectual property from commercially exploiting such property. So if I have an intellectual property, I should have some legal rights through which I can protect this intellectual property. For that, we have got intellectual property rights. So as per the TRIPS agreement of WTO, we have got 7 forms of intellectual property rights. So many of these terms may be aware of, you may be aware of that. We have got patents, then copyrights and related rights, trademarks or service marks, industrial designs, geographical indications, layout design of integrated circuits, and trade secrets. So we have got 7 forms of intellectual property rights. Depending upon the type of the property we are inventing, we have got 7 forms of intellectual property rights. And in this session, we will cover all these 7 forms. So first, we will see what patent is. So you may be much aware of the term for patent. Okay. It's a familiar name, patent. So patent is nothing but patent protects inventions, new inventions, new inventions are protected by the intellectual property, which is known as patents. So as I said, invention. So invention means it should either be a new product or a new process. Only a new product or a new process can be patented, and it comes under the definition of invention. And what patent will give us? If I invent something and if I got a patent for that invention, I will have the exclusive right to make that product, to sell that product, and use that product. And without my permission, nobody else can do any of these activities. So that is the exclusive right which is being granted by the government, which will be granted by the government of a particular country to the inventor. So if I am the inventor of an invention and I got a patent for that, I will have the exclusive right to commercialize that product. Without my permission, nobody else can use or copy my invention. That is the exclusive monopoly right we are getting through this patents. So what do you have to do to get a patent? If you have an invention and if you would like to get a patent for that, first thing you have to do is you have to disclose your invention to the government. You have to disclose your invention to the patent office. In exchange of that, patent office will issue you the patent certificate. Okay, so that certificate will be valid for a limited period of time, and during that period, you have the exclusive right over your invention. And if you have an invention, if you have invented something, and if you are not willing to disclose your invention to the government, you won't get a patent. You can seek some other protection, but you won't get a patent for that. So for getting a patent certificate, we have to fully disclose your invention to the government. And patent rights are basically territorial rights. That means an Indian patent will be valid only within the geographical boundary of our country. That is, Indian patent will be valid only within India. So if I have got an Indian patent for a particular product, I have the exclusive right to prevent others from copying my invention or from using my invention in India because I have the rights within India. But I cannot prevent a person who is copying my invention outside India because I have got a patent which is valid only within the country. If you want to prevent others from copying your invention in other countries also, what you have to do is you have to file patent in each and every country. Okay, patent rights are basically territorial in nature, and the protection of patent will be limited for a period of 20 years. That means 20 years you have the exclusive right over your invention. At the expiry of 20 years, your patent will become a public property, so that anybody else can make it, anybody else can use it. You won't have any rights after the period of 20 years. The maximum term of protection is 20 years. And in India, the patenting system is governed by the Indian Patent Act 1970. So many amendments have come, but the basic Patent Act is Patent Act 1970. Another important thing to note is that discoveries are not patentable. As I said, patent protects invention. So inventions can be patented, whereas discoveries are not patentable. You know the difference between an invention and a discovery. So only inventions are patentable and discoveries cannot be patented. So in order to get a patent, as I said, invention means it should either be a new product or a new process. So in order to get a patent for an invention, it should satisfy three conditions. These are the patentability criteria. They are novelty, inventive step, and industrial application. So these are the three patentability criteria to pass to get a patent protection. So first one is novelty. So novelty is nothing but new. The invention should be new. That means it should not be published anywhere anywhere in the world in any of the languages. The details of the invention should not be published anywhere. Okay, it should not be published in a media, it should not be published in a journal, magazine, websites. It should not be published anywhere before you file the patent application. So that is one condition, not published, and it should not be in prior use also. Before filing the patent application, it should not be in the prior public use. That is another condition, and it should not be patented anywhere in any of the country, not only in India. It should not be patented in any country. So that is another thing, and it should not be in prior public knowledge. That means till the time of filing the patent, the invention, the details of the invention should be kept secret. Only at the time of filing a patent only it should be published. Okay, that's what novelty means. The invention should be new. So if you have any invention and if you would like to file a patent for that, first thing to do is that don't publish it anywhere. Don't publish it anywhere. Keep it secret and file the patent, and after that you can publish it. That is the first condition. That is novelty. Then second one is it should have an inventive step. So inventive step means there should be some technical advancement in your invention. There should be some technical improvement in your invention or some economic significance, which makes the invention not obvious to a person skilled in the art. That means a person who is having an average knowledge in the field of your invention, he should not be able to identify what you have done. So that is the technical improvement in your invention as compared to the existing products. As compared to the existing product, there should be some technical advancement, or it can be an economic significance also. For example, if we have a technology available, but it is available at a high cost. So if I am coming up with an alternate version of that same technology, but without compromising the quality, if I can sell it at a lower cost, then it is economically significant. So that will also be considered as an inventive step. So it should either be a technical advancement or there should be some economic significance in your invention, and it should not be clear to a person who is having an average knowledge in that field. That is the second step, that is inventive step. And third one is industrial application. Industrial application means it should be capable of being made or used in the industry. It should be a useful invention. It should be made or used in the industry. So these are the three criteria to pass to get a patent protection for an invention. So all the inventions are not patentable. As I said, a patent protects invention. Even though patent protects invention, there are certain inventions which are not patentable in India. So in the Patent Act, we have got two sections, that is section 3 and 4, which says what are all inventions which are not patentable, even if it satisfies the patentability criteria of novelty, inventive step, and industrial application. If the invention belongs to any of these categories, your invention will not be patented. Okay, so these are some of the inventions which cannot be patented in India. So first one is the frivolous inventions or the silly inventions, the inventions which does not have any use. So they are known as frivolous inventions. Such inventions are not patentable, or inventions which are contrary to the well-established natural laws or scientific theories. So the inventions which claims anything contrary to the established natural laws are not patentable in India. Then the inventions which are contrary to the public order or morality. For example, if I am inventing a device for committing theft easily. Okay, if I invented a product like that, even though it satisfies the patentability criteria, you won't get a patent for that because it is against the public morality. So such inventions are not patentable. Or any invention which is against the health of human beings or plants, such things are also not patentable in India. The new form of a non-substance or the new property of a non-substance, that is mere discovery only. We are just finding out the new property or the new use of a non-substance. Such things are not patentable. Then substance obtained by mere admixturing of non-components. So if we have got some components which is already available and it has got some property, and if I'm simply mixing these components and come up with a new product which has the same effect of that of individual components, then it is not patentable. Then arrangement or mere arrangement or rearrangement of non-devices working independently. For example, an umbrella fitted with a torch. So we have umbrella already, we have umbrella, and we have a torch or maybe fan. Okay, umbrella fitted with a fan. So fan is also available. So what I have done is I have merely arranged these two components into a single product, and if it works independently of one another, it is not patentable because it is just a mere arrangement or rearrangement of the non-devices. Then very important thing is that method of agriculture or horticultural methods, that process is not patentable. Whereas if you invent a device or an equipment to perform agriculture, then that can be patented, whereas the method of agriculture is not patentable in India. Then anything which is related to traditional knowledge, the paramparya vijnana, traditional knowledge. So any invention which is related to the traditional knowledge is not patentable because that is not a private property, that is the property of a particular community. So you won't get a patent for the traditional knowledge related inventions. Then mathematical methods, business methods, algorithms, computer programs, per se, such things are not patentable. If you have a business idea, if you have a business concept or a mathematical equation or a mathematical method, or if you have invented an algorithm, or maybe, such things are not patentable in India. Computer program per se means if you have a source for a computer program or a mobile application, such things are not patentable in India. These are all protected under the right which is known as copyrights, not patentable in India. Then presentation of information is not patentable. The literary, dramatic, artistic, and musical work, all these are protected under copyrights. Then inventions which are related to atomic energy. Atomic energy related inventions are also not patentable in India, or similarly defense related. If you have invented an equipment which is useful for the defense purposes, then you won't get a patent for that. What patent office will do is that they will refer your invention to the DRDO, and if the invention is useful to the country, then patent of the country, the government will take that invention from you and you will be compensated. But you won't get a patent for a defense related invention. And very important thing is that method of treatment or a method of diagnostic disease, that method, that process is not patentable. For example, if a doctor invents a new method of doing an operation, that method is not patentable. Okay. Whereas if you have invented a surgical device or a medical equipment, that is patentable. Whereas the method of treatment or method of diagnosis is not patentable in India. So these are the inventions, even though it satisfies the patentability criteria. If the invention belongs to any of these category, that invention will not be granted patent in India. So we always have a big that only complex inventions are patentable, only breakthrough inventions, maybe rockets, satellites, such kind of inventions are only patentable. It is not like that. As far as patent is concerned, simplicity is no bar for getting a patent like that. That means for getting a patent protection, it need not be a breakthrough one, it should not be a complex invention, it is nothing like that. Okay, so only thing is that it should satisfy the patentability criteria. That's all. So you know about what an invention is. Inventions are basically solutions, right? Solutions to the problem. So if you are solving a small problem, it will be a small invention, and maybe if you are solving a breakthrough problem, it will be a breakthrough invention, not or maybe. So if it satisfies the patentability criteria, simplicity is no bar for getting a patent protection. The best example for this simplicity in patenting relates to this, that is safety pin. So safety pin, you are all aware of this safety pin. So safety pin was a patented invention. Patent was granted to the safety pin in 1849 to an inventor named Walter Hunt in US. The patent was issued by the United States Patent Office in 1849. And after 20 years, that got expired. Patent got expired, but safety pin was a patented invention. So simplicity is no bar for getting a patent protection. Similarly, the same inventor only has invented the fountain pen, and for that also he got a patent in 1847. Suppose you have an invention, maybe a small invention, maybe a breakthrough invention, whatever it may be. So if you have an invention in your hand, you have got two options. First one option is you can publish it, or second option is you can patent it. So publishing means you can publish it in a journal, magazine, media, wherever you want, you can publish it. The thing is that once you publish your invention, you will get some recognition out of this publication, right? So the disadvantage is that once you publish your invention in a journal or a website or a magazine, after that you won't get a patent. You won't get a patent for the same invention after publishing it in a journal, because once the invention is published, the novelty part, newness part is lost. You yourself have published it, but it doesn't matter. Once the invention got published anywhere, the novelty of the invention is lost. After that, you won't get a patent for that. On the other hand, if you are opting for a patent, you are opting for filing a patent. If you file a patent today, if you are filing through online, today itself you will get the application number. Next day you can publish it wherever you want. Okay, you file a patent in the patent office today, you get an application number. Next day you can publish it wherever you want. So by doing that, you will get patent as well as you will get the recognition out of this application. So we always advise that if your invention is worth filing a patent, just file a patent first, and after that only go for publication. Otherwise, you won't get a patent for that invention. So if you are opting for a patent filing, first thing you have to do is you have to do some process called patent search. So usually when you are doing some research work, you will be doing some literature survey. So before selecting a topic for research, you will be doing some literature survey. Similarly, if you have an invention, first thing you have to do is you have to do a patent search. So why you should do a patent search? A lot of reasons are there for doing the patent search, because you have an idea. You have an idea, you are working out on that idea, and you are coming up with a new invention, but you are not aware whether somebody has done in any part of the world, whether somebody else has already done the same invention. So if he has already done the same invention, you won't get a patent for that. So to check whether the invention is new, whether your invention is new and whether it is patentable, you have to do the patent search. And also, if you're opting for filing a patent, you have to pay some fees, like filing fee, publication fee, examination fee. Some fees are involved there for filing a patent. So before making such expenses, you should make sure that your invention is worth filing a patent, because if the invention is already been invented, then there is no point in filing a patent for that. Sorry. So for that also, you have to do a patent search to check whether it is worth filing a patent, and based on that, you can take a decision whether the patent should be filed or not. Maybe once you do the patent search, you may come across with some similar inventions, maybe in America or Europe, wherever maybe. So you may come up with some similar inventions. So in that case, what you can do is you can study that document. You can study that document and you can identify the disadvantages of that particular invention and come up with a solution to that problem. So you can modify your invention accordingly. So that also is possible by doing the patent search. And patent search will also give information about the owners as well as the inventors of the existing patents. You will get the information regarding the ownership of the existing patents, and you can also identify the competitors for the same technology, because you came to know that who else are working on the same technology. That information will also be available by doing the patent search. So these are the reasons for doing the patent search. And these are some of the online databases, freely available online databases in which we can do the patent search. So first one is the website of the Indian Patent Office, that is ipindia.nic.in. So if you do a patent search in that website, you can check whether any Indian patent is being granted on the same topic. So as I said, patents are always territorial in nature. So Indian Patent Office will have the details of only Indian patents. Excuse me. Sorry. So that is the first website. That is the website of the Indian Patent Office. So we can find the details of the Indian patents. So second one is the website of the US Patent Office. There you can find the details of US patents, whether any US patent has been granted on the same topic. So that is another thing. So the reason why I have highlighted is these IP India as well as Google patents. So, I don't know how many of you are aware that there is something called the Google patents. So usually we are very familiar with the Google web search. Okay? We are very familiar in conducting the Google web search. Similarly, we can conduct the patent search in Google itself. So google.com/patents. That is Google patents. We can do the patent search in Google patents also. So Google patent covers the patent documents of almost all the countries except India. Okay, that's why it covers the patents of US Patent Office, European Patent Office, Singapore, many countries. It covers the patents of such countries. So the thing you have to do is you have to do a patent search first in Google Patents and also in the website of IT India. That is the website of Indian Patent Office. By doing the patent search, you came to know that, and maybe it will not be 100% sure, will not be there, but maybe 80 to 90% we can make sure that the invention is new or not. So that is what patent databases are. This is the website of the Indian Patent Office where you can find the menu patents. Okay, there you can click on that. This is the search page. Okay, you can do the search. You can do the search wherever you want. You can type the keywords. The keywords related to your invention. You can type it here, and it will get the details of the invention. This is the Google patent search. So this is how we can do the patent search in Google. Okay, similar to the web search itself. I just put the keyword as gesture control television, and we can do the Google search. And once you do the Google patent search, only patent documents will be cited. These are the patent documents which are available on with the same keyword. That is gesture control system like that. So you can click on this link. It will go to that particular patent document. You can see here. So there will be an abstract. You can first thing you have to do is you have to read the abstract. By reading the abstract itself, you can make sure that your invention is whether it is related to your invention. Like that, you can do that. So you can even download the PDF version of such application also. Okay, so these are the in short, these are the steps to conduct the patent search. So you conduct the patent search and you are confident that your invention is worth filing a patent. Then next step is filing the patent. So in India, we have got 4 offices, patent offices, with patent office at Kolkata and having branches at Delhi, Mumbai, and Chennai. And this is the Chennai Patent Office, our patent office. So all the patent applications from the southern states has to be filed in the Chennai Patent Office. And as far as patent is concerned, who can apply for a patent? So for applying for a patent, there is no age limitation, there is no qualification barrier, nothing like that. Only thing is that you should be inventing something. You are the inventor of that particular invention. Okay, any person who is the true and first inventor, they can apply for a patent or his assignee. If I invented something, I can assign somebody else to file patent on my behalf. So I can assign. So assignee can also apply for a patent, or in the case of a deceased inventor. In the case of a deceased inventor, the legal representatives can also file the patent application. So this is the patent grant procedure. So the next session will be regarding the patent rules, patent acts, and also I hope that this topic will be covered by the next speaker. So I am not going into the patent filing procedure. So this is the patent certificate. So this is the certificate you will get from the patent office. If the invention is patentable, you will get a patent certificate like that. It will have a patent number like that, and it will have an application number. Then date of filing will be there, and patentee means that the name of the patentee, that is the owner of the patentee. And this certificate will be valid for 20 years. That's the proof that you have got a patent for the invention. So recently, the patent amendment rules 2021 has came into effect. I think from 21st September only. So what it says that educational institutions will have the same fees as that of the individual startups and small entities. Earlier, there were separate fees for no fees for individual startups and small entities, and for the educational institutions, the fee was very high. So earlier, the fee was for filing the patent was 8,000 rupees. So now, as per the patent amendment rules, it has come down to 1,600. So what educational institution means, any university or any institution which has been established under the central government or the state government, which includes all the government, aided, private, any institution, any educational institutions comes under this category, and the fees for filing the patent application from such institution has come down to maximum, because right from 8,000 rupees, it has come down to 1,600. So it is a remarkable change which has been made very recently by the patent office. So this is the fee structure. You can see that for filing a patent, as I said, for filing a patent, there will be some expenses involved. So at the time of filing the patent application, you can file the patent in 2 ways. You can either file the patent electronically, that is e-filing is there, or you can file it physical filing is also there. This is the fee structure of e-filing. So for filing a patent, the fee will be 1,600, and for early publication it will be 2,500. Examination fee will be 4,000, and expedited examination 8,000 rupees. That is applicable for individual, startup, small entity, as well as educational institution. And we can here you can see the renewal fee. As I said, patents are valid for 20 years. So right from third year to 20th year, you have to pay the renewal fee to keep the patent in force. Only by paying the renewal fee only, your patent can be extended up to 20 years. Every year you have to pay the renewal fee. So as I said, term of patent is 20 years from the date of filing of patent application. Okay. Not from the date of grant of patent. From the date of filing the patent application, the term will start. You may get a patent, and the normal course it will be 3 to 4 years time to take. So the term will count from the date of filing of the patent application. So as far as patent is concerned, there is a big myth called there is something called a world patent or international patent. It's not like that. There is nothing like that. As I said in the first slide itself, patent rights are basically territorial in nature. Okay, so there is nothing like a world patent or an international patent, but there is a shortcut with which we can file a single international application. Application you can file it. You won't get a patent globally, but you can file an international application. For that, we have got Patent Cooperation Treaty, that is PCT. PCT is an international treaty. India is also a member of this treaty. So the advantage is that if you want to file the patent outside our country, first thing you have to do is you have to file an Indian patent first. And after 6 weeks, you can file a PCT application, again in the Chennai Patent Office by paying the fees. So by filing that PCT application, your application will get priority in all the 152 member countries. 152 member countries in PCT. You will get priority for 31 months time. So you will get a priority for your invention in all these 152 countries. And what you have to do is you have to decide in whichever country you have to file. After that, you have to file it fresh there in such country separately. But the thing is that you will get a priority, and within that period, nobody else can file a patent for the same invention in such country. That is the advantage, you will get it. And within that period, you can file separately in each and every country in which you would like to file. That is why for that we have got PCT application. So finally, as far as patent is concerned, don't lose the chance for getting a patent by publishing it. If you publish it, novelty is lost, you won't get a patent, and don't use it in the public also. If you are using it in the public and somebody else came to know about that, then again, they can also oppose in the patent filing procedure, they can also oppose. So don't use it in the public also, and don't wait for the full development. We always have that feeling. We will say that let us wait till it gets complete. It's not like that. If somebody else copied your invention, if they file patent first, they will get the patent. So as far as the patent is concerned, those who file first will get the patent first. It's not like that. Those who invent first. Okay, so don't wait for the full development. Apply as soon as the idea takes a definition. There is something called a provisional specification that will be covered in the next session. So just file a provisional specification and don't wait for the full development. So these are the precautions we have to take if you would like to file a patent for that. So that's all about patents. As I said, we have got 7 forms of intellectual property rights. Since patent is the most important topic among these all 7 forms, I have covered in detail. So now I will just quickly go through the other forms of IPR also. So next one is copyright. So you're all well familiar with the term copyright, right? Copyright. Is it the right to copy or right not to copy? Any answer?
Right, not to copy.
Yes, exactly. It's the right not to copy. Okay. So as I said, copyright patent protects new inventions, new products or a new process are protected under copyright. It means patents. Whereas copyright protects creative works like the literary, artistic, or scientific works. Such things are protected under the intellectual property, which is copyright. Okay, so that also same thing. We can protect our literary work. If you have written a book, if you have written a novel, if you have written a story, poem, whatever maybe, any literary work. If you wrote any literary work, you can seek for copyright protection. So copyright will protect such works, literary works, dramatic works, then musical works, artistic works. Any creative works are protected under copyright. Cinematographic films are protected, sound recordings, sound broadcasting, television broadcasting is there. Then computer program per se, as I said earlier, computer programs, such things are patented, can be registered as copyrights. Then algorithms, business methods, business concepts, such things are protected under this copyrights. So copyright nothing but copyright will protect the expression of thoughts based on some idea. So there is a big myth called like I have an idea. Many images are approaching us by saying that, sir, I have an idea. I want to get a copyright for that idea. It's not like that. Idea cannot be protected under copyright. Idea cannot be protected under patent. If you have an idea, idea will be the base for any invention or any creative works. But if you have an idea, if you want to get a patent for that idea, what you have to do is you have to convert that idea into a product or a process. Then it can be patented. Similarly, if you have an idea and you want to get a copyright for that idea, what you have to do is you have to express that idea into a tangible media. You have to write it in a piece of paper or you have to record it into a tangible media. Then only you can protect such work. Idea as such cannot be protected by any form of intellectual property right. So copyright will protect the expression of ideas and it will give us a bundle of rights. Copyright. It will give us the right for reproduction. Okay, then right for adaptation and translation. If you have written a book in English or Malayalam, you got a copyright for that, you will have the exclusive right to translate it to any other language. Without your permission, nobody else can do. So that right for a translation right, you will get it. Right of distribution also you will get it. Then right of public performance. That also comes under copyrights. Right of broadcasting. So bundle of rights are being given to the owner of this copyrights. These are the subject matters of copyrights: architectural works, books, literary works. These are the paintings, such unique paintings, original paintings are protected by copyrights. Drawings, original drawings can be protected. Sound recordings, then photographs. So these are all protected under copyrights. Regarding the authorship of the copyright, in the case of a literary work, who is the author of the copyright? Is the author of the work. Those who have authored that book, he will be the author of the copyright. Whereas in the case of a music, it will be the composer. Music, it will be the composer. Singers and other all musicians will have some related rights will be there, but the ultimate copyright owner of that particular music will be the composer. In the case of an artistic work, it will be the artist. In the case of a photograph, the photographer is the owner. Cinematographic film or a sound recording is the producer and not the director. Okay, so producer is the author of the copyright for a cinematographic film or a sound recording. And for a computer-generated work or literary dramatic work, those who creates the work. So these are the authors of a copyright. So copyright protection is basically for 60 years. So you can see that patents are for 20 years only, but whereas copyright protection is for 60 years. And in the case of a literary work, it will be the lifetime of the author plus 60 years. So he can enjoy the protection up to his lifetime, plus after his death, up to 60 years, his legal representatives can enjoy the copyright protection. Okay, so that is the term of copyright protection. And in the case of a cinematographic film or a sound recording, it will be 60 years from the date of registration. And whereas in the case of a broadcaster's right and performer's right, it will be 25 years. So as compared to the patent, the term of protection for copyright is much higher because it is minimum 60 years you will get the copyright protection. Another difference between patent and copyright is that patents, as I said, patents are territorial in nature. That is, Indian patent is valid in India only. Whereas in the case of a copyright, if you got a copyright from the Indian Copyright Office, that right will be valid internationally. You need not have to register for copyright in each and every country. You will get the international right through this copyright protection. So that is another difference between copyright and patent. So in India, we have got only one copyright office, that is at New Delhi. So all the application has to be filed in the New Delhi office only. You can file it online or through physical filing. You can do that. That is what copyright means. Then another important thing is that filing of patent is mandatory for for getting the patent protection. Whereas in the case of a copyright, registration is not mandatory. So if you have written a book today, at the completion of that work, that copyright belongs to you. Only thing that you should prove that you are the real author of that work. Okay. So copyright registration is not mandatory, but we always advise that it's a very simple process only, and fee is also very cheap. So it's better that you get a certificate because it will take some 2-3 months only to get a copyright granted. So if you have got the copyright certificate, it will be easier to prove in the future if any infringement comes. If you have the certificate, it will be very easy to prove that you are the author of that work. So as per the Act, copyright registration is not mandatory for getting the protection. This is the fee structure. In the case of a literary, dramatic, musical, or artistic, only 500 rupees. That is the only fee, no renewal fee. By paying this fee, you can enjoy the protection up to 60 years. In the case of literary work, it will be up to your lifetime plus again 60 years. You can enjoy the protection. No need to pay the renewal fee. And for the cinematographic film, only 5,000 rupees. And for sound recording, 2,000. And it will take maximum 3 to 4 months time to get it granted. That's what copyright is all about. So next form of IPR is trademarks. You'll be very much familiar with the term trademark, right? Especially the brand. So trademark is nothing but the companies or the enterprises. They will be using some distinguishable symbols. Why they are using some symbols to distinguish their products from those of its competitors. So for that, trademarks. Okay, the companies or maybe even individuals can also do that. They can create a logo. Okay, so just the purpose is just to identify the source from where this product is coming, from which company the product is coming. Just to identify the source or the origin of that products, that companies will be using some distinguishable sign or symbols. So that is what trademark. So just by seeing this logo itself, the customer would be able to identify the source of that product. That is what trademark means. It will be represented graphically and in a non-descriptive. These are all the examples of this trademarks. Okay. And different types of trademarks are there. It can be a word mark like Ford, Toyota. So that is a word only. Or it can be an abbreviation like IBM. It can be numbers, letters, slogans, sound, and even smell. So slogan, you may be aware of the various slogans. Dil Mange More, express yourself, like that. Many slogans are there. They are all trademarks. Trademark one slogans are there. Okay, so just to make the customers sure that this product comes from a particular company. So for that, companies are using the mark, which is known as trademark. Logos, combination of colors, holograms, all comes under this trademark. So there is something called service mark. Service mark is nothing but the companies or the enterprises, they will be using some distinguishable sign or symbol to distinguish their services. For example, insurance, LIC. Okay, so they're offering services only, not manufacturing. They're offering services. So to distinguish their services from its competitors, they are using some mark. Banking, like South Indian Bank, State Bank of India, like that. Hotels, educational institutions. So if your institution is going for filing a trademark, it will be a service mark because you are offering service. So you can apply for a service mark. Transportation like Indian Railways, KSRTC, and research laboratories like CSIR, DSP, like that. So the companies or the organizations which want to distinguish their services from its competitors, they will be using the service mark. Similarly, we have certification mark. You are aware of that. ISI mark, ISO mark, Hallmark, BSA. Because the products which has got a particular quality standard, such things are being protected under the certification mark. Then there is something called collective mark. Collective mark means the marks which will be used by a group of persons. For example, doctors. You are very familiar with this symbol. This is the collective mark of doctors. So they would like to distinguish themselves from others. Okay. For that, they are using a mark, which is known as a collective mark. So that any doctor can use this mark. Similarly, chartered accountants, engineers, they can also use this mark, right? Collective marks. So this is the fee structure for filing a trademark. It will be 4,500. And initially, the protection will be for a period of 10 years. And after that, you have to pay the renewal fee. That is, the renewal fee you have to pay. Again, you will get protection for the next 10 years. Okay, so every 10 years, you can enjoy the protection. So that is what trademark means. Okay. Then another thing is that so the protection will be initially for a period of 10 years and you can renew indefinitely because every 10 years, by paying the renewal fee, you can enjoy the protection indefinitely. That is the advantage of trademark. It is not like that, or not only, as I said, not only companies, if individually, if you have created a logo, maybe for a personal purpose or maybe for an education purpose, whatever maybe. If you have created a unique logo, you can apply for a trademark. So after getting the trademark registration, only the thing is that only you could be able to use that mark. Without your permission, nobody else can use that mark. You might have seen the TM, the TM mark. You can say. Once you file that application, you can use the TM, and once the trademark certificate is received, you can use the mark like R in a circle. So it shows that it is a registered trademark. So that is the case of trademarks. So as per the Global 500 2021 ranking, uh, you can see that the brand value. Okay, the brand value. This is the name of the brand. You can see that Apple is ranked number one. That is with 263 billion US dollars just for the name of that Apple. You can see that it is in the rank position. Second one position is Amazon. They have got 254 just for the name of that brand. That is known as brand value for Google, Microsoft, and all. So that is very important. The brand value of every company is very important. So next form of IPR is industrial design. Industrial design means the aesthetics of a particular product or a product. If it is a unique one, the external appearance of a product, if it is unique from the existing one, then it can be registered as an industrial design. As the name suggests, industrial design. It's the design of a product is being protected under this industrial design act. So it is not connected with any functional aspect. Only thing is that for example, that you take the case of the shape of this bottle. If it is unique from the existing bottles, we can apply for a design registration. Only the shape will be protected. Okay. So these are the examples of some of the design registered. Only thing is that the features of shape, configuration, pattern, such things are protected under industrial design. Only condition is that the design must be new. The design must be new and original. Okay. And initially, the protection will be for a period of 10 years. These are all the examples of registered designs. Ornaments, all the ornaments are being registered there industrial design because based on the design only we will be selecting these ornaments. So design adds value to that product and it's a very important intellectual property right also. So if we create a new product which is unique in shape or configuration, you can apply for the registered design. The shape of all the vehicles, then television or laptop, mobile phones are all registered as industrial design. Shape of a pen, carpet, these are all the examples of registered design. This is the fee structure, only 1,000 rupees is the fees and the renewal fee is 2,000. Protection will be initially for a period of 10 years and it can be renewed for 5 more years. So maximum term of protection you can enjoy is 15 years for industrial design. So next form of IP is geographical indication. Geographical indication means the goods which originates from a particular geographical region, geographical origin. If it has got some qualities, unique qualities, reputation, and characteristics that are attributable to that place of origin, then it can be registered as a geographical indication. It is known as GI. That means a particular region, it has got a uniqueness, it has got characteristics and reputation that are due to that place of origin only. Such products can be registered as geographical indication and it will be applicable only for goods, not for any other services and not like that, only for goods only. geographical indications are applied. So it must originate from a defined area. The function is that to identify the origin from where this product is coming. That is the function of GA, to identify the origin of the goods. And any association of persons, producers, or organization can apply. Apart from the other forms of IPR, geographical indication cannot be applied by a individual because it is not because of his effort that product is having such quality. So all the producers who are making such products in that region, they can use the GA tag. These are the examples. Darjeeling tea. So by simply hearing the name itself, we can identify.
Am I audible now?
Yes, sir.
Okay. Just now only I came to mute.
Yes, sir.
Okay. Okay, these are the examples of the Indian GA like Darjeeling tea, Kanchipuram sari, Agra petta. And as far as the Kerala is concerned, we have got a number of products. More than 30 products are there from Kerala which has got the GA tag like Navara rice, Palakkad and Matta. So by hearing the name itself, we can identify that the product from where the product is coming, like the Palakkad and Matta rice, Haipad rice, Armula Kannadi. Because only the producers of these products can sell these products by this name. That is the advantage. Only the producers in Aramula region who is making the Aramula Kannadi, they can market the product in the name Aramula Kannadi. That means Aramula Kannadi cannot be made in Trivandrum or any other region. It should be made in Aramula itself. So that is the purpose of granting a GA registration. Marayor, Jaggery, Nellambur, many products are there which has got the GA tag. For the registration of good, it is 5,000 rupees, and for an authorized user, it will be 500 rupees. Similar to that of the trademark, the GA protection is initially for a period of 10 years. So 10 years will be the initial period, and similar to that trademark, we can renew it indefinitely by paying the renewal fee. Every 10 years, we can renew it and you can enjoy the protection indefinitely. That is what GA means. The next form of IPR is semiconductor IC layout design. It is not that important as far as the other IPs are concerned. That is the topography of semiconductor IC. The IC, you know that in the integrated circuits we will have many components like diodes, transistors, and others. So the layout of such components, if it is a unique one, if it is an original one, that can be registered as an IC layout design. So the term of protection is 10 years from the date of filing. And finally comes to trade secret. That is the final form of intellectual property rights. And you are all very familiar with the Coca-Cola, the recipe of Coca-Cola, right? So the recipe of Coca-Cola is an example of this trade secret. So in the first slide I said, if you have an invention and if you want to get a patent for that invention, you have to disclose it to the government. So if you are not willing to disclose it, the other option is you can keep it as a trade secret. Okay, so the advantages are there, disadvantages are also there as far as patent and trade secret are concerned. So Coca-Cola, what they have done is they refuse to disclose to the patent office, and they have opted for the trade secret. So they have kept their recipe as a trade secret. So trade secret, by keeping it as a trade secret, you need not have to register anywhere. It is the responsibility of the company or the individual to keep it as a secret. Okay, so as long as you can keep it as a secret, you can enjoy the protection of trade secret. But once the secret is leaked, it's lost, you cannot enjoy because that protection is lost because it is not registered legally anywhere. They themselves are keeping it as a secret. So what they have done is they have kept it as a secret, and still they continue to keep it as a secret so that they can enjoy the protection. So if they would have filed a patent at that time, at the expiry of 20 years, the patent would have been expired, and even we could have if we could have make the Coca-Cola recipe in our home. But no, it's not that the case now, because they have kept it as a secret and still they are enjoying the protection. Okay. And when the trade secrets are preferred like that, when the invention is not patentable, you can opt for the trade secret, and patent protection is limited to 20 years, as I said. But whereas trade secret can be kept beyond that period. If you are able to keep it as a secret, you can. And for filing the patent, some fee structure will be there. But for keeping it as a trade secret, you do not have to pay any amount. Okay, these are all the other examples like the Cadbury Dairy Milk, KFC. So their recipes and all, they have kept it as a trade secret. Advantages are there because once if you have applied for a patent, 20 years protection is guaranteed. But in the case of a trade secret, if it gets leaked, protection is lost. So advantages and disadvantages are also there. So that's all about the 7 forms of intellectual property rights. And what you have to just check that we always feel that a single product can be protected by a single intellectual property. It's not like that. Take the case of a pen. If I have invented a new pen, just imagine that it is a new pen, newly invented pen. So how can we protect this pen by intellectual property? Any intellectual property? Which IP we can use it for this protection of this pen? Any answer?
For design.
Design, yes, design. If the shape of this pen, if the shape is unique, you can apply for design protection. Yes. Then any other answer? No. If the pen is maybe like a Parker pen, then it can be registered as a trademark, right? Parker pen. Okay, that brand, the brand of that pen can be registered as a trademark. And similarly, the technology, that the inflowing mechanism, the writing technology is there now. So that can be protected by patent also. So a single product can be protected by multiple IP. So this pen can be protected by patent, maybe by design as well as by trademark. So single product can be protected by multiple form of intellectual property rights. So that's all about the overview of intellectual property rights regarding the role of IP in entrepreneurship, especially for startups and all. So you may be well aware that because as far as a technology startup is concerned, the survival of every startup will depend upon they should have some unique technology. If a startup has got an unique technology, they can survive. Otherwise, they should have some unique service they are offering. So intellectual property is the most valuable asset of any technology startup, because for obtaining the venture capital or for preventing competitors from copying your product, you have to protect your intellectual property like that. And what thing they have to do is that if you are having a startup and you may approach some investors for a support like that. So first thing they will look is that how many patents you have got, whether you have got any patent, whether you have got any trademark protected like that. So if you have a unique product or a unique technology which is been patented, then they will approach you. They will take your company, they will support your company, and also intellectual property is very much important. Not only patent but also logo. If your logo, the logo of the startup is also very crucial to your success, because it has got an integrity. It ensures that okay, this has got some integrity of the brand like that. It's very important. And not only patents and trademarks, you can apply for the designs. As I said, if it is a unique one, you can apply for a design, and if it is a non-disclosable one, then you can apply. You can kept it as a trade secret also. So all the forms of intellectual property will be applicable for every startups. So first thing you have to do is you have to make the IP protection as a priority. You have to prioritize whichever IP you want to protect. Like that, first thing you have to do that, and then register for the IP. Or if you have got any unique technology, then apply for a patent. Then that logo, if you want to register, you have to register through this designs like that. Brand, trademark like that. So first you prioritize the IP rights and then apply for the IP registration. And another thing is that you should make sure that you are not violating the IP rights of other companies. That is very important, because knowingly or unknowingly, if you are copying somebody else's products or technologies, they will sue you. Okay, so it's very important that you should make sure that you are not violating the IP rights of any other companies. That is very important, and you should have a IP policy also. If a technology comes out, how to protect that. So what you have to do is, if you are having a startup and if you are applying for a patent, the best thing to do is that file the patent in the name of the startup itself, that company, not in the name of individuals. Just file the patent or any other IP in the name of that startup only. Then only that will grow. And you can fix some agreements. Any agreements like the non-disclosure agreements, you can sign agreements with the employees not to disclose the technologies to others like that. That also you have to do. And you may be aware that the government of India has introduced a scheme for the startup, that is the scheme for facilitating the startups IP protection, SIPP. And all the startups are recognized by the DIP, that is the Department for Promotion of Industry and Internal Trade. They can apply for that. The condition is that they have empaneled the facilitators. So if you have a technology, if you want to file a patent, you have to approach a patent agent or a patent attorney for drafting and filing the patent application. So patent office itself has empaneled a number of facilitators for supporting the startups like that. So if you are registering in this DIP, and what you can do is you can approach the facilitators. That the details will be available in the website of the patent office. You can approach them. Only thing to do is that you need to pay the official fee only. Only the fees to be paid in the patent office. The fees for the empanelers or the facilitators will be paid by the government. So by that route, you can enjoy the you can save your expenses also. That is the advantage of having a startup. So many of you may be aware of this startup like Gen Robotics. They were a startup in the Kerala Startup Mission. So they have invented a robotic scavenger, okay, to clean the manual holes and all. So first they have done is that it is an award-winning technology also. They got the support from the government of Kerala and all. And what they have done is that they have filed a patent in the year 2017. On their own, they have filed a patent in the name of their individuals only. And next year they applied for a application to convert the earlier application to a provisional application, and they filed patent in the name of the company itself. Okay, and after 1 year, again they applied for a fresh application by converting the earlier application to provisional, and recently they have filed it in the international patent application also, and it is the patent procedure is also underway. So by getting the patent itself, they got recognition and they got many works and all. You can just log into the website of this Gen Robotics. They were a very small startup with a few members only, but now they have grown up to a high because of this IP protection and all. So that is the case study of this Gen Robotics. And just to show that a young graduate in Kenya, what he has done is that he had developed a phone charging shoes. Okay, shoes with which we can charge our mobile phone. And he has got a startup company like Hatua Technologies, and now he has got many clients, and he has got many recognitions like that. He has got support from the government and all. And what he has done is that this is the shoe. So pressure-based mobile phone charger only is there. So this is the connector. You can just connect a USB to your phone, and it will get charged while walking itself. So walking motion exert pressure on the piezoelectric crystal. He has put a crystal here, so you'll get some energy which is being converted to the electrical energy. By walking itself, you can get your phone charged. And he has filed a patent in 2006. And after that, his life has changed drastically. And similarly, recently only, young inventor named Philip Frenzel. He's just a 25-year-old master student at Alien University in Germany. He has invented a smartphone case. That is a mobile airbag. It's nothing but this one. If it has got features like that, so if your phone gets dropped from your hand, so it will get activated and you can protect your phone. It won't get damaged. So he has invented a mobile airbag case. It is a case. It is a case, and after just keeping, you can just keep it. So he has applied for a patent in 2017, and after that he has got many recognitions. So he is a graduate, and he has startup and all. Just to give you a glimpse of some entrepreneurs, young entrepreneurs who has converted their ideas into the technologies. Just to for that. And before I conclude, just a few slides like IP management. Like if you have a patent, you have got the right to exploit the patent. You can assign the patent to somebody else. You can even surrender the patent, and you can sue them for any infringement. And we can transfer the patent rights also. Okay. So there are three ways in which we can transfer the patent rights. That is, one way is you can assign it, or then license it, or operation of law. These are the three ways in which we can transfer our rights. First one is the legal assignment. Through an agreement, we can assign the rights of your patent to another party. Then he will be the new author of that patent, like that. And similarly, license is the very important thing. License means there will be a licensor as well as a licensee. So it will be based on a written agreement. There are different types of license also there. That is a voluntary license. Voluntary license means I am giving a license to a third party for exploiting the invention for a limited period. That is voluntary license. There is something called a statutory license also, because you got a patent. You got a patent for a particular product, but you are not working that product, and you are not keeping that product available to the public. So since you have got a patent, nobody else can use that product also. So in such case, patent office can intervene, and they can issue a compulsory licensing to any other party who is willing to make it available to the public. That is what statutory licensing means. Then we have got exclusive license. Like I can give an license, exclusive license. I can give a license to a particular company, or non-exclusive license also I can give it. Because I have invented something, and if I want to commercialize that invention to the public, if I am not having such facilities, the only thing to do is that I have to give a license to other companies and get the royalty from that. So that is the thing. And in the case of operation of law, when a patentee dies, all the rights related to the patent will passes to his legal representatives. So that's all about the overview of intellectual property rights. If you have any queries, you can email to me, or you can call me. We will be providing all the services with regard to this intellectual property rights. So before we conclude, as I said earlier, we'll have a small quiz related to this session. So what I will do is that I will stop sharing my presentation, and I will share the link. I will share the link of that Google form in the chat box. It's a self-assessment of what you have understood from this session. That's all. Don't be panic, and you will get the score itself at the time of submission. You will get the score, how many you have done. Hope you got the link.
Yes, sir.
Okay, there are just 15 questions only. You can take maybe 10 minutes. That's all. Maximum 10. I'm asking for your 10 minutes time. Just fill it and
Sure,
submit
sir.
it.
Thank you, sir, for that extremely informative session. It's not only beneficial to the would-be entrepreneurs, but general awareness essential to all disciplines. Sir, now do we have time for asking questions and queries from the side of the participants?
Yes, we can. I think we can wait for that a few minutes. Okay, let them complete this quiz, and after that we can interact.
Okay, sir. Participants, please complete the quiz. You can access the quiz by clicking on the link given in the in-call messages. We will resume the session after 10 minutes, and then you can ask your questions and queries to sir.
If you have any questions, you can ask now.
All participants are requested to come forward with their doubts and queries and utilize the knowledge of this efficient resource person. You can either unmute your microphone and ask the questions, or you can even put them in the chat box.
ക്വസ്റ്റ്യൻസ് എങ്ങനെ ഉണ്ടായിരുന്നു? ഹലോ ഹലോ
Yes, sir.
audible ആണോ?
Yes.
എനിക്കുള്ളൊരു ഡൗട്ട് എന്താണെന്ന് വെച്ചാൽ, നമുക്കിപ്പോ ഒരു പ്രൊഡക്റ്റ് മിസ് ഓഡിബിൾ അല്ലേ മിസ് ഞാൻ പറയുന്നത്?
കേൾക്കാം.
ഓക്കെ സാർ, നമുക്കിപ്പോ ഒരു പ്രൊഡക്റ്റ് നമ്മുടെ മാർക്കറ്റിൽ അത് അവൈലബിൾ ആണ്, ഇതിന് സെയിം യൂസ് ആണ്, പക്ഷെ ഇതിന്റെ ടെക്നിക്കൽ മെത്തേഡ് വേറെയാണ്. ഒരേ പ്രൊഡക്റ്റ് യൂസ് സെയിം ആണ്, പക്ഷെ അതിന്റെ ടെക്നിക്കലി അതിന്റെ എക്കണോമിക്കലി അത് ചേഞ്ച് വ്യത്യാസമുണ്ട്, അതുപോലെ തന്നെ ടെക്നിക്കലിയും അതിൽ ചേഞ്ച് ഉണ്ട്. അപ്പൊ നമുക്കത് പേറ്റന്റിന് വേണ്ടി ആപ്ലിക്കേറ്റ് ചെയ്യാൻ സാധിക്കും.
അതെ, ആപ്ലിക്കേഷൻ ഇപ്പം സെയിം തന്നെ ആണെങ്കിലും ടെക്നോളജി വൈസ് ഇഫ് ഇറ്റ് ഈസ് ഡിഫറെന്റ് ആണെന്നുണ്ടെങ്കിൽ, പിന്നെ അത് മാത്രമല്ല അതിനകത്തുള്ള എന്തെങ്കിലും ലിമിറ്റേഷൻസ് നമുക്ക് സോൾവ് ചെയ്യാൻ പറ്റുന്നുണ്ടെങ്കിൽ ദാറ്റ് മേ ബി കൺസിഡേർഡ് ഫോർ എ പേറ്റന്റ്. അത് ഇൻവെന്റീവ് ആയിരിക്കണം ആസ് കമ്പയർഡ് ടു ദാറ്റ് എക്സിസ്റ്റിംഗ് പ്രോഡക്റ്റ്. അത്രയാണ് അതിന്റെ കണ്ടീഷൻ. ക്ലിയർ ആയെന്ന് വിചാരിക്കുന്നു.
അതുപോലെ തന്നെ അതിന്റെ എക്കണോമിക്കലിയും അത് ഈ പറഞ്ഞ പ്രൊഡക്റ്റിനേക്കാൾ എക്കണോമിക്കലി അതിന് റേറ്റ് കുറവായിരുന്നെങ്കിലും അത് പേറ്റന്റിന് അപ്ലിക്കേറ്റ് ചെയ്യണം.
അല്ല, അത് തന്നെയാണ്. അത് ഞാൻ നേരത്തെ പറഞ്ഞായിരുന്നല്ലോ, ഇൻവെന്റീവ് സ്റ്റെപ്പിനകത്ത് നമ്മൾ ഒരു എക്കണോമിക് സിഗ്നിഫിക്കൻസ് പറയുന്നുണ്ട്. ഓക്കെ, അപ്പൊ നമുക്ക് ഹൈലി അഫോർഡബിൾ അല്ലാത്ത നമുക്കൊരു ടെക്നോളജി ഉണ്ടെങ്കിൽ നമുക്ക് അതിന്റെ ഒരു ഓൾട്ടർനേറ്റ് വെർഷൻ നമ്മൾ കൊണ്ടുവരികയാണ് എന്നുണ്ടെങ്കിൽ, അത് എക്കണോമിക്കലി സിഗ്നിഫിക്കന്റ് ആണെന്നുണ്ടെങ്കിൽ അത് ഇൻവെന്റീവുമായിരിക്കും. സോ ആ ഒരു കണ്ടീഷൻ പാസ് ചെയ്യാനാണ് പാട് വരുന്നത്, ഇൻവെന്റീവ് സ്റ്റെപ്പ് എന്ന് പറയുന്നത്. ഓക്കെ, അപ്പൊ എന്തായാലും ഒരു പ്രോഡക്റ്റിന് എന്തായാലും ഒരു നോവൽറ്റി ഉണ്ടായിരിക്കും. ഒരു യുണീക്ക് ആണെന്നുണ്ടെങ്കിൽ ദർ ഷുഡ് ബി നോവൽറ്റി. അപ്പൊ ഇൻവെന്റീവ് സ്റ്റെപ്പും കൂടെ നമുക്കത് ക്ലിയർ ചെയ്യാൻ പറ്റുവാണെന്നുണ്ടെങ്കിൽ വലിയ ഒബ്ജക്ഷൻ വരാൻ സാധ്യതയില്ല. നമുക്ക് ട്രൈ ചെയ്യാവുന്നതേ ഉള്ളൂ.
സർ, ഒരു ഡൗട്ട് ചോദിച്ചോട്ടെ. ഇപ്പൊ ഞങ്ങളുടെ സ്റ്റുഡൻസിന് ഇതുപോലെ ഉണ്ടെങ്കിൽ കേരള സ്റ്റേറ്റ് കൗൺസിൽ ഫോർ സയൻസ് ടെക്നോളജി ആൻഡ് എൻവയൺമെന്റിന്റെ സപ്പോർട്ട് കാണും, ഇങ്ങനെ പേറ്റന്റ് ഫയൽ ചെയ്യുന്നതിനൊക്കെ നമുക്ക് ഹെൽപ്പ് സീക്ക് ചെയ്യാൻ പറ്റുമോ?
തീർച്ചയായും.
ഞങ്ങൾക്ക് ഇപ്പൊ ടെക്നോളജി കുട്ടികൾ എന്തെങ്കിലും പ്രോഡക്റ്റ് കൊണ്ടുവരുമ്പോൾ അതിന്റെ ടെക്നോളജി എല്ലാ സൈഡും ഞങ്ങൾക്ക് ടീച്ചേഴ്സിന് അതിന് ഫെമിലിയർ അല്ലായിരിക്കും. അപ്പൊ അതിന്റെ ഒരു എക്സ്പേർട്സുമായിട്ട് കൺസൾട്ട് ചെയ്തിട്ട് അത് മുമ്പോട്ട് പോകാൻ പറ്റുള്ളൂ. അപ്പൊ അങ്ങനത്തെ കുറച്ച് ഒബ്സ്റ്റക്കിൾസ് ഞങ്ങളുടെ മുമ്പിലും ഉണ്ട്. അപ്പൊ ഞങ്ങൾ ആരെയായിരിക്കും കറക്റ്റ് ഇത് അങ്ങനെ ഒരു ഇത് വരുമ്പോൾ ഞങ്ങൾ അപ്രോച്ച് ചെയ്തത് മുൻപോട്ട് കൊണ്ടുപോകേണ്ടതെന്ന് അറിയാനായിരുന്നു.
അതെ, നമുക്ക് ACST-യിൽ നമുക്കൊരു ഇന്റലക്ച്വൽ പ്രോപ്പർട്ടി റൈറ്റ്സ് ഇൻഫർമേഷൻ സെന്റർ എന്ന് പറഞ്ഞാൽ ഐപ്രിക് എന്നാണ് അതിന്റെ പേര്. അപ്പൊ അത് കേരള സ്റ്റേറ്റിന്റെ നോഡൽ ഏജൻസിയാണ്. അതായത് IPR റിലേറ്റഡ് ആയിട്ടുള്ള സർവീസസും IPR റിലേറ്റഡ് മാറ്റേഴ്സും ഹാൻഡിൽ ചെയ്യുന്ന ഗവൺമെന്റ് ഓഫ് കേരളയുടെ നോഡൽ ഏജൻസിയാണ് ഐപ്രിക് എന്ന് പറയുന്നത്. അതായത് നമ്മളുടെ ഓർഗനൈസേഷൻ തന്നെയാണ്. അപ്പൊ അവിടെ നമ്മൾ എല്ലാ സർവീസസും നമ്മൾ കൊടുക്കുന്നുണ്ട്. ഞാൻ നേരത്തെ പറഞ്ഞ ആ പേറ്റന്റ് സെർച്ച് എന്ന് പറഞ്ഞ ഒരു പ്രോസസ്സ് നമുക്ക് നിങ്ങൾക്ക് അത് ചെയ്യാൻ പറ്റത്തില്ല എന്നുണ്ടെങ്കിൽ ആ ഒരു സർവീസ് നമ്മൾ ഇവിടെ ചെയ്യുന്നുണ്ട്. ഞങ്ങൾക്കൊരു പേറ്റന്റ് ഫെസിലിറ്റേഷൻ ഫോം ഉണ്ട്. ആ ഫോമിനകത്ത് നിങ്ങളുടെ ഇൻവെൻഷന്റെ ഡീറ്റെയിൽസ് ഫില്ല് ചെയ്ത് ഇവിടെ തന്നാൽ ഞങ്ങൾ പേറ്റന്റ് സെർച്ച് ചെയ്തിട്ട് അത് പേറ്റന്റബിൾ ആണോ ഇല്ലയോ എന്നുള്ളതിന്റെ ഒരു റിപ്പോർട്ട് നമ്മൾ ഇൻവെന്റേഴ്സിന് കൊടുക്കാറുണ്ട്. പിന്നെ അത് കഴിഞ്ഞ് അത് പേറ്റന്റ് ഫയൽ ചെയ്യാനാണെങ്കിലും നമുക്ക് KCSCക്ക് ഒഫീഷ്യലായിട്ട് പേറ്റന്റ് അറ്റോർണി ഉണ്ട്. ആ അറ്റോർണി വഴി നമ്മൾ കൺസെഷണൽ റേറ്റിൽ തന്നെ നമുക്കത് പേറ്റന്റ് ഡ്രാഫ്റ്റ് ചെയ്ത് ഫയൽ ചെയ്ത് കൊടുക്കുന്ന ഫെസിലിറ്റിയും നമുക്കുണ്ട്. റൈറ്റ് ഫ്രം പേറ്റന്റ് സെർച്ച് തൊട്ട് പേറ്റന്റ് ഫയലിംഗ് വരെ സപ്പോർട്ട് ചെയ്യുന്ന സ്കീംസ് നമുക്കിവിടെ അവൈലബിൾ ആണ്. അപ്പൊ അതുകൊണ്ട് ടീച്ചറിന് അങ്ങനെയുള്ളവരെ എല്ലാം നമുക്കിതിലേക്ക് ഡയറക്റ്റ് ചെയ്യാവുന്നതാണ്.
ഓക്കെ, താങ്ക് യു സർ.
താങ്ക് യു. ഒരു 20 റെസ്പോൺസേ കിട്ടിയോളൂ. ബാക്കിയുള്ളവർ ചെയ്തുകൊണ്ടിരിക്കുകയായിരിക്കും. സോറി, 33. ഈ ക്വസ്റ്റ്യൻസിനകത്ത് എന്തെങ്കിലും ഡൗട്ട് ഉണ്ടായിരുന്നോ? സെഷൻ വൈൻഡ് അപ്പ് ചെയ്യുന്നെങ്കിൽ ചെയ്യാം മാഡം. ഡൗട്ട്സ് ഒന്നും ഇല്ലെങ്കിൽ.
Okay, Miss. Now we are winding up this session. Thank you all. For now, we will disperse for the time being, and let's meet again at 3 p.m. for the second lecture. Thank you, sir. Thank you, teachers. Thank you, friends, for all joining today.
Thank you, madam.